Hi, I'm Greg Dell. I'm here with attorney Stephen Jessup, and we're going to answer questions about Principal Life Insurance Company. And Jessup specifically, we're going to try to talk about denials and then the appeals of those denials, because it's a really important opportunity that disability insurance companies, when they deny a claim, they basically say, look, you don't have to sue us. We can try to resolve this in an appeal. And if the claim happens to be governed by ERISA, which is a federal law, in that situation, they're not doing you a favor. You're required by law to file this appeal. And Principal, as you know, does ERISA, which is group governed, group issued, employer issued disability policies, but they also sell individual disability policies. But in these questions today, I want to focus on, if I'm a person sitting at home and I got denied by Principal, what kind of things do I want to know? What kind of things should I know? So the first question that comes to mind for me is, if I've been denied by Principal, do they ever really reverse any of these denials?
I'd say yes. I mean, it's not like all of a sudden you're never going to see the benefit again. You know, going back to what you had said too, when someone contacts us and they say, hey, we have a case with Principal, first thing I want to know, is it a group employer provided policy or something they purchased on their own? Because it's going to be a little different, you know, from the legal aspect. But as a whole, whether it's an individual or an employer provided ERISA policy, Principal is going to conduct the same level of review. In my experience, Principal does better reviews than, say, like a Hartford or a Prudential leading up to a denial. It's not like they just have an in-house case manager look at it and deny it. But that being said, though, they usually do a lot more due diligence on the front end in denying a claim, so it can be a little more difficult to overcome the denial. Where some insurance companies will just deny for a ridiculous reason, and you have a much stronger ability to create new information.
And I think the reason for that and what you're saying is, look, the Principal is going to have a more thorough denial letter because they don't have the volume of what a Prudential, a Unum, a MetLife, Hartford, New York Life, like you were saying, where they're selling, you know, they're trying to get millions of insureds. I'm sure Principal would like to have that many, but it's just not their niche in terms of what they do, so they don't have as many. Because of that, they're able to dial in and focus more on what they're doing. So you might find more detail in a Principal denial letter. And we tend to work with a lot of the same adjusters. I also think, to Principal's credit, they tend to hire more experienced or educated, qualified claims person. So when you do find a denial, it may not be the nonsense like you were saying, you know, where they're denying. Principal may actually take the extra step and kind of look for some more information before they deny, and then say, let's see if the person comes back with an appeal. All right. When you go ahead and say, I got hired on this claim, I'm requesting the claim file, which is all of the records that Principal had. They're going to give us everything, assuming it's governed by ERISA. You're going to review all of that, and then I know you're looking for specific information in there that's going to shape your strategy. But what are those things?
You know, it's always going to be, because disability is how your medical condition prevents you from doing your job or some other job, depending on the language. So if you strip it down to the basics, the medical and the vocational. So the first thing I'm looking for in any claim file is their medical reviews and their vocational reviews. And any correspondence, since they do have to turn everything over, from the claims manager reaching out to the medical reviewer or the vocational staff saying, hey, this is what I want. It's basically, you know, showing you what exactly they're thinking and shaping. So pulling out those medical reviews and vocational is first and foremost the most important thing to find within the claim file.
And then you get that information and you now see the way that the Principal was thinking, and you develop a strategy. And after you put together this whole strategy of how you're going to go about your claim, information's going to come back, right? And you're going to have everything, and then you're going to send it into Principal and say, here's all the new information we got. Here's here's why we disagree with you. And Principal is going to go out, and they're now going to take everything you sent them and hire a doctor, allegedly, or have the claimant examined, and that information is going to come back. So now this appeals person is looking at everything that Stephen submitted on behalf of the client and everything that they did, however they go about doing it to get information. Ultimately, there's this disability appeals claims person at the Principal who needs to now make a decision. And they got your information on behalf of the client and the information they got. Which way does the claimant does the principal appeal specialist usually go in this scenario?
It depends. If it's a case that I've done the appeal on myself, just from personal experience of how many times I've actually had to file lawsuits against principal, which are, few and far between compared to the other insurance companies. In the appeals that I've personally submitted, they usually side with us. And whether that's a matter of the presentation of the information and even how I like to present it and write appeals. A lot of times you could be firing accusatory of you guys did all this kind of stuff wrong and attack them. I like to take a more of approach of, I understand where you're coming from, but this is why I think you're wrong, and if you take another look at it, and then what to build in. Because in the medical records, the reviews, it's going to discuss what's missing. If they're saying if it's a physical condition, there's nothing to verify, physical restrictions and limitation from desk level work and all those things. There's testing that can be done to document that, and then working with the doctor. So I think in my personal experience, doesn't happen all the time, but with principal, if you give what they say is missing and you have the doctor support and the information lines up, they tend to do the right thing more often than not, compared to other insurance companies where I may sue a certain insurance company 30 times in a year because it's the same rinse, wash, repeat review. But it all goes back to what you're giving, right? If you try to do the appeal on your own and you rush it and you don't have any extra, new medical information or testing that can verify things or doctor support, well, you're only as good as the information. So if you don't give good information, they're going to default to rely on what they've done in their own reviews.
What type of time frame from when a person's denied by principal until you could get a decision to either uphold the denial or reverse the denial should someone expect?
I tell people, worst case scenario, think 9 months, because you have 180 days to submit the appeal. They'll have 45 days initially, an extension of 45 days, so 9 months. Worst case scenario. Generally, I wouldn't. That's not the case. I like to try to have appeals in within 3 months because you got to wait for getting the claim file, getting all the information. But I tell people, I understand you don't have money coming in; they've cut off your benefit. But if you file your appeal today, they could technically still take 3 months to make a decision, and you haven't given them anything good. So it's really a difficult thing for someone who doesn't have money coming in to say, hey, this could take 6 to 9 months before you get a decision on it. But you may be talking about what's going to happen over the next 10, 15, 20 years. So that 6 months is really a small amount of time in the scheme of things. And again, it always goes back to how much information is already available. How much has to go into it. If you don't have supportive doctors, it's going to be a lot harder. So there's going to have to be more things done to try to, garner that. As much as we see similar patterns in denials in cases and what should be in certain types of cases, at the end of the day, every single case is different based on the medical condition, how supportive doctors are, and the vocational aspect of it. But I tell people worst case 9 months, but expect it's going to be at least 6 months.
If a claimant with a principal disability policy is approved for Social Security disability, can principal disagree with the finding of disability, or do they have to say you're disabled for Social Security, therefore you're disabled under our policy? So
they don't. So the law is clear that receipt of Social Security doesn't require the insurance company to pay you. It's just strong evidence in support of disability. I've seen situations during the appeal process where Social Security is awarded. Right? So, hey, Social Security just said you can't do anything. Principal thinks you can do something. Social Security just said no. And then I've still seen ultimate denials, not necessarily with principal, but other companies where they say, well, Social Security has a different criteria by which they do it. It's based on age, other factors. Oh, and we have additional information that Social Security didn't have by their doctor's reviews. So, yes, it's strong evidence, but it doesn't mean they're going to approve. And I know you've seen it, we've all seen it, where the Social Security is approved during the appeal, they still uphold the denial, and then they send you a letter for the overpayment. We want our money back. So, they're going to, use it any which way it can potentially, help them.
Is principal, during the appeal, after you submit all your information, are they required to rebut your evidence, or in a way of rebutting their evidence, the evidence that you submit, to hire a doctor to physically examine the claimant in order to, have a leg to stand on to dispute what we're submitting?
No, so they don't have to have an outside doctor look you physically examine. The policy is going to allow them the right to have you examined, and if you don't go, they can deny, but they're under no obligation to have you examined. And from my experience, if you're not sent to an IME prior to a denial, it's a greater than likely chance you won't be during the course of the appeal. Normally, independent medical evaluations will happen prior to a claim denial. So on appeal, it's generally outside peer review doctors, hired through a third-party company just to review your file and render an opinion.
But even though, and that is the trend, they usually don't do what we call an independent medical exam or compulsory medical exam on appeal, but it is a fresh look on appeal where someone totally different is supposed to look at it. So doesn't it seem logical that the best way to evaluate the person would be to look at them, physically see them, touch them, hear them, as opposed to just relying on a
It would be,
record?
and a lot of times when you look at denial letters, you're like, it's logic that you wouldn't be able to work, but they're not thinking in the realm of what's most logical. It's always what's most advantageous. And as we know, IMEs can be a slippery slope. Say they do send you to someone, and that doctor just toes the same line. I think this person could work, especially under an ERISA-based disability policy where you have to show that they acted arbitrary and capricious. They now get to go, hey, we even had them physically examined, and this doctor told us they didn't think restrictions and limitations were applicable, so how are we unreasonable in denying the claim when we did these things to rely? So that can get murky as well, but I would agree. If you want to best assess, it's physically examining the person. But those examinations, sometimes you hear clients say it was 5-10 minutes, they barely spoke to me, they checked my reflexes, called it a day. It's not like they're sending in-depth functional testing of any sort.
Right, but there are strategies that say, like, I know if we send our clients, we're going to possibly videotape it, we're going to record it, we might send an independent witness to go with them because we don't want it to be a he said, she said type situation. So there are strategies to take if you have been requested to go to one of these things, but I just think it's a dollar thing for principal to say, look, we're not going to spend $1,000 or $750 or $1,500 on every claim that we evaluate. If we can get a doc to look at it for a couple $100 and courts have accepted this, that's why we're doing it. But I think it's a fallacy in the system, and you can't accurately determine, especially someone's subjective complaints, just by looking at paper. But what it does suggest is that when we do these appeals and when claimants submit appeals, you've got to be super detailed on what your complaints are. You've got to get them in the record over this period of time that you have once you've been denied, and you've got to really work and get the doctor to comment on what your restrictions and limitations are and what all of your complaints are and how that relates to your inability to do your job. Because if you don't get that in there, principal's likely not going to have anyone look at you. They're just going to eat apart your records. And that's why we always stress it is so important to have great evidence that is put together in the appeal. And like we always say, look, 80% of the work we do in this appeal is what we do from the moment you hire us to obtain all this additional evidence to make this appeal great. That's what makes it great. If you don't have that, you might as well you're just writing like nonsense without obtaining. It's like, where's the beef? That's what we say. You got to bring the beef to there and say, this is what's different, this is what it is, and make it so that when their doctor gets it, they would go, no human being with these types of findings or these types of complaints could possibly go to work. And if the doctor does disagree, then we're ready at court because the judge is going to look at it and go, this is ridiculous. And all these other cases say that if this, and that is in a record, it's ridiculous as well, and this person should be disabled. So all factors that we go into all the work we do, and we try to put these videos out there so people know, be aware, you got to do a great job. I know it's frustrating and you want to get it done quick. You can't rush it, and you got to do it the right way. So if you have a principal long-term disability claim, feel free to reach out to myself, Stephen Jessup. No matter where you live in the country, we're available to assist you. We look forward to providing you with a free phone consultation and discuss your principal disability claim.